No matter your age, your plan for retirement can start today. From the News Channel 5 Network, this is the Retirement Report.
Good morning. Welcome to the Retirement Report. I'm Hank Parrott, your host. I'm going to be talking about mistakes of estate planning, the top estate planning mistakes, basically some basic information first off on estate planning, what the difference between a will and a trust and what powers of attorney are about, and other documents that you need for a good estate plan. We're going to talk about the 5 essential documents, in fact, that form the foundation of any good estate plan. And we'll talk about how probate works and get into some discussions about mistakes to avoid, what some of the consequences might be, and how to set up a good estate plan. So with me to help with that today is Russ Cook with Russ Cook & Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney. I got it out right that time. Over in Brentwood, he's one of the few in the area you'll find, and that's all he does is estate planning. He specializes in that and dealing with all matters related. We might even touch on some of the more advanced things if we have time this morning. So one of the things, Russ, and we get into estate planning, of course, is just starting with some basics, and one of those being what exactly is probate. So this is one that in some states probate can be really problematic as far as expensive and time consuming, but here in Tennessee it's not quite that bad.
No, it's not actually. We have a system here, and it's basically county driven too, in a sense, where a lot of the work that needs to be done to open a probate can be done either through the emails or just meeting with the clerk and master. There's no formal court proceeding. And of course that depends on what we're working with when someone passes away. If you have a will and you pass away and the will is properly written, then usually the probate process involves taking the will down to the courthouse with a petition where you request the judge to rule that the will is valid and asking the judge to go ahead and appoint an executor who's the person that is in charge of managing the assets. If you pass without a will, then probate can be a little bit more burdensome because you're asking the court then to pick you to be the administrator of the will. You're not, or administrator of the estate. There is no will. Administrator of the estate, and there are many people in your family that could claim that right. So with a will, you have someone appointed specifically. Without a will, then it's a matter of the court deciding who may be the best person to do this. And then you have to jump through more hoops in order to get the estate administered, depending on the assets in the estate. So again, in Tennessee, you can do that mostly over in a short period of time. But the problem that comes up sometimes is when you have more complicated situations, even more so than just having no will, where you have family fighting and things like that. That's when probate ends up being a pretty big deal.
And this is the other, if you don't have a plan, if you don't have at least a will done, if not maybe a trust, but let's stick with the will part. If you don't have at least a will done, if you die without a will, then of course the state has a plan for you. So if you don't have a plan, they have a plan.
They have a plan.
And their plan may not, one, it's going to be pretty simplistic relative to the plan you may prefer in terms of how you want your estate handled. But two, it may cause some things to happen as far as division of assets between, say, a spouse and children that may not have been your intent as well.
Yeah, that is the most problematic situation, is when a client passes away and doesn't have a will, and let's say there's a surviving spouse and children. You would assume most people want all their assets to go to their surviving spouse. Well, if you pass away and don't have a will, then the surviving spouse is sharing the estate with the kids. And the surviving spouse gets a child share, but no less than a third. And there are some ways you can actually get it up to 40%. But most cases, when a husband dies or a wife dies, they want everything to go to their spouse. So you certainly want to have something in place in order to avoid that problem.
So, and this is an area then if you get into maybe a second marriage, or you may have children from a previous marriage, and maybe even 2, maybe 3 ex-spouses. How might that all work into what if this new spouse has children? Are those stepchildren going to now have a claim on your estate potentially?
Well, if you don't adopt the children of your spouse, if they remain stepchildren, then they're not legally entitled to a share of the estate. But certainly when you have conflicting interests, where you have a spouse that was thinking they were getting 100% of the estate and instead they're getting 30 or 40%, or you have kids that think they should get more, then you've got a situation where people are just not on the same page. The first problem you run into in that situation is who's going to be the one appointed the administrator of the estate. Is it going to be the new spouse? Is it going to be one of the kids? It should be a neutral party, because in 90% of the cases we deal with, that never goes well when either of those, either a kid or a child or a spouse, ends up being the administrator. So that increases the costs of administering the estate immensely.
This is one of the areas too. If you think about, we see this quite often, where people have been married maybe before, come together and marry later in life, maybe both have children from their previous marriages, and they want their assets to go to their respective families. They want to take care of each other. Well, if you haven't done some planning, this isn't going to necessarily go the way you may want it to go, the way you intend for it to go. And in particular, when it gets into intestate laws, or whether you don't have a will or don't have something written down to say how things are to go. And another part of that is when you get into joint ownership of assets. So if you're coming together and you're married and you now maybe you buy a house together, but your goal is that that house is going to be divided, or your intent may be that that house, then the monies you put into it, your half would go to your children, and the new spouse's half goes to their children. Well, if you haven't set that up in a plan, and typically what's going to happen is you've got a passing by contract. So in this situation, Russ, a lot of times people accidentally disinherit children unintentionally through lack of planning.
Yeah, this is going the other way now, where you have a situation where everything the spouse owns is owned jointly with the new spouse. So instead of the assets passing through an estate where they possibly could be divided, they're all going to go to the surviving spouse. And this is a situation that we see problematic more so than the one where people pass without a will and it gets divided between spouse and kids. Because in these scenarios, we've seen it time and time again where one spouse dies, surviving spouse inherits everything, and then the kids of the first spouse to die get nothing. And even when there's promises made, and I've been in the room when promises have been made, there's no guarantee that those promises will be carried out, and that's something that you want to make sure you plan very carefully for.
This is one of those areas where you're thinking you're going to take care of your children. You haven't, and you set up a will and you say, I want divided in this manner. But if you own these assets, whether it's a house or investment property or joint bank accounts, joint investment accounts, brokerage accounts, anything that's owned jointly goes to the survivor of the two of you. So all that, it may be written in the will saying that they get half, it never goes that far. It gets passed out by joint ownership. It's never a part of the estate. Therefore, you've disinherited people. You may be, again, unintentionally. So I'm stressing this mainly, the importance of planning and getting these things down and having a document, but not just having the document, but understanding what else needs to take place. And this is where a trust can be very beneficial. And we'll get into that in a moment. But before, let's get a slide up that shows you what exactly is probate. I'm going to back up a little bit and talk about this piece of it. So the definition, as Russ was just talking about, what probate is, but the other part is what it does. Okay, resolving disputes, paying off creditors, an inventory of assets to be divided up, appraising assets for values, potentially change title of assets. So in other words, if you've got that house that you want to pass on to your heirs, now then this is how that goes, okay, that how that's going to get taken care of, as well as other accounts that need to have title changes, and distribute one's estate. So that's orderly distribution. However, as we were just talking about, there are a lot of ways that can get that can be problematic, and then there's some reasons you might want to avoid probate. One of them is the publicity factor. Okay, if you like to keep your affairs private, probate is a public forum, and all your assets and everything that you own and who it's going to and where, for that matter, their addresses and everything are all part of public record, and anyone can go into the probate clerk and look up those files and see what's in there. The delay, how long it takes. Typically probate's going to take about a year typically to go through. And then the fees, and as Russ and I were talking earlier, Russ, the fees in Tennessee aren't as bad as maybe in other states. So here, depending again though on the attorney and the county, I mean there are different things that can still cause that to be certainly more than what doing some planning up front would be. Okay. So when it comes to estate planning, we were just talking about some areas there and why planning is so important. Now, one of the areas I want to touch upon is that of a trust. So first off, on the estate, that's all your different assets. So that can be brokerage accounts, cash in banks, real estate, personal property, vehicles, all of those things are part of your estate. So estate planning then is allowing you to choose who's going to control that estate upon your death, among other things. So it's how your assets are going to get distributed. So this is it. Now you work quite a bit with trusts, and in fact preferably over that of wills in terms of the in the difference. Let's talk about setting up a trust, and then you also do testamentary trusts within wills, the pros and cons of those.
Well, the first thing we look to when we're meeting with a client is this client going to benefit from a revocable trust instead of a will? A will, as you know, is the document that you sign, you take down to the courthouse and get it validated by the court, and you go through that process that Hank just described. Revocable trust is a way for you to create right now, or the day you sign it, a document that doesn't have to be presented to the court in order for it to be effective, because it's effective when you sign it. And if you title your assets in the name of the trust, and think of it as kind of a bucket that you put your stuff in. If you title your assets in the name of the trust, you can still manage and control them the same as you would if you own them individually, because you are the trustee, you are the beneficiary. The trust doesn't necessarily have a separate tax ID number, it doesn't file separate tax returns. It's just kind of there to hold your stuff so that in the event of your passing, those same assets don't have to go through a probate proceeding because they're already titled in a trust that dictates where those assets go. So if you have a joint trust between husband and wife, one spouse dies, the other continues on managing the trust as trustee. And then when the survivor dies, you name maybe a kid or two to be trustee, and they just continue to manage the trust according to your wishes, distributing the assets among the family members without having to go through a court proceeding to get that done. Testamentary trusts come into play whenever you're giving assets to someone through either a revocable trust or a will, and you're wanting to protect those assets from that person's creditors or spouses and other issues that might come up during their life. So you don't give them the inheritance outright, you give it to them in trust.
There you go. So we're going to dive into that more. We're going to take a quick break. When we come back, we'll talk about what estate planning is and how it can work for you, and how kind of tying these things together, and then again going over the different documents in more detail as well. This is really going to help you quite a bit when we just talked about some of the potential pitfalls that come with not doing planning. There's also pitfalls that can come if it's not done correctly. So we want you to, keep pen and paper handy there for notes, right? Because we're going to help you get it set up and get it set up right. So first a break. Join us here. We'll be right back on the Retirement Report.